Hello, my name is Melanie Gold. Welcome to the information session for the Access to Appellate Justice Pilot Program, or as we call it, ATAJ. And congratulations on being accepted into the program. You are part of a nationwide civil Gideon movement that seeks to provide access to justice for civil litigants not only in the trial court, but also in the appellate courts. San Diego has been on the leading edge of this movement, providing a monthly workshop to help educate self-represented litigants on the mechanics of bringing an appeal. But for those of you who have volunteered in that program, we have seen that gaps remain. Litigants still have trouble perfecting a record and making reasoned arguments. Without this ability, the appeals are often dismissed on procedural grounds at the early stages, creating both the appearance and the reality of not being served, of justice not being served. This pilot program seeks to address this problem by helping low-income, self-represented appellate litigants find an attorney who's willing to represent them on a pro bono basis. This concept has been supported at the highest levels in this court. As the California Supreme Court Chief Justice Contil Sakue recently stated, we must ensure that income inequality doesn't translate into a two-tiered justice system. Your help in this program is a win-win on so many different levels. For the justices, approximately 1/3 of the cases in the Court of Appeal 4th Appellate District Division I have at least one self-represented party. And attorney assistance on these cases is invaluable. For the clerk's office, to reduce time spent with self-represented parties. For the litigants, regardless of the outcome, attorney representation will enhance a critical component of our justice system, which is providing litigants with procedural fairness, which builds confidence and trust in the courts. You will be hearing from 3 speakers today. First, Lisa Cannon, who is a law professor at the University of San Diego School of Law. Second, David Kay, who is a sole appellate practitioner who has represented non-institutional clients for going on 40 years now. Third, Kevin Green, a certified appellate specialist who has practiced in San Diego for 20 years. So Lisa will first go over the ATAJ program mechanics. David and Kevin will then walk you through a typical appeal, highlighting issues that would tend to arise when representing parties who were not represented in the courts below. Specifically, David will discuss issues pertaining to the attorney-client relationship, the notice of appeal, the civil case information statement, and the true filing requirements. Kevin will then discuss record designation, briefing, oral argument, and opinion and post-opinion matters. If you have questions about the program mechanics, you can email the program at sandiegoataj@gmail.com. And on substantive questions, remember, we have a fantastic mentor panel, and another excellent resource is the step-by-step appellate manual that you will find on the Court of Appeals website. We thank you so much for your participation in this program, and good luck.
Hi, I'm Lisa Cannon, and I'm going to be talking to you today about some of the mechanics of the ATAJ program. So first of all, to go over the qualifications for being in this program, to be an attorney who helps on the panel for this program, you have to have your own malpractice insurance. You have to have no record of any kind of disciplinary history with the bar. And additionally, you need to have had 3 years of experience plus 1 completed appeal in a California state or federal court, or 5 completed appeals in a California state or federal court. Lead attorneys may also work with other associates and younger attorneys who don't meet those qualifications, so long as the lead attorney maintains responsibility for the case. For the litigants in our program to qualify, first of all, we are only going to be accepting people for the program who were unrepresented in Superior Court and continue to be unrepresented, and the other side in the case was represented by counsel. This is how we're going to judge eligibility for now. And it may be that in this case later on, the other side becomes pro se, but we're going to continue to consider this as a qualified case, as long as at the initial time we're screening the case, one side is represented and the other is not. We'll also be only accepting cases that are pending in the 4th Appellate District, Division 1. And finally, the case must be one where the applicant qualifies for a fee waiver. Now, at the time that we are screening these cases, most of the applicants will simply have filed their request for a fee waiver. The Court of Appeal may not have actually granted that fee waiver yet. And some of these applicants may have had a fee waiver in the Court of Appeal, or the Superior Court. However, they have to apply anew for the Court of Appeal. Having a fee waiver means that they don't have to pay for any filing fees or the cost of the clerk's transcript. We are going to leave it up to our counsel, once they take a case, to verify that the Court of Appeal has actually granted the fee waiver. Now, here's how our program works in terms of selecting cases. The process begins when a pro se applicant fills out our Google form. That information is put into a spreadsheet that our screeners will review. Once they determine that the case is qualified, then we will automatically move information over to a Google sheet that all of our panel attorneys will have access to. These screeners will periodically email all of the panel attorneys to let them know that new cases are available. This Google Sheet's going to provide you with basic information that you can use to check for conflicts. It'll indicate the names of the parties in the case and some other basic information about the case, so you can determine whether or not you're interested in taking the case. To tell us that you're interested in taking the case, you'll add a comment to the Google spreadsheet to indicate your interest. And it's fine if several attorneys indicate that they are interested in taking the case. What we will end up doing is sending that information to the applicant, and then the applicant will be able to reach out to attorneys to speak about whether or not a relationship should be formed. So the applicants will contact the attorneys directly to negotiate that representation. David will be speaking more about how that representation will come to be. Finally, we ask that if you are successful in establishing a representation with one of our applicants, that you email the program back to let us know. Finally, I want to talk to you about the mentors who are available to assist you with your case. So once you've decided to take a case and establish the representation, the ATAJ program won't supervise you or continue to be involved in the case. It's going to be your case. However, we do have a group of mentor attorneys who've agreed to provide assistance to you in terms of advice. The mentors are going to provide us information that we will put into a Google spreadsheet that we'll share with you that will indicate the mentor's area of expertise and the kinds of assistance that they are willing to provide. And one important part of that is that the mentors, many of them, are going to be available to help you moot your case before it goes to oral argument. So interested attorneys will be able to add a comment on that Google spreadsheet to indicate that they are interested in the case. At that point, we will send you some basic case documents so you can further explore the representation. And if you are indeed interested in taking the case after that, we will then email the applicant directly with your contact information so that the applicant can reach out to you to determine whether or not you will form a representation. David will be providing more information later on about how you can establish that representation. Finally, we just ask that after you do establish a relationship with the applicant, that you email the program to let us know that that has taken place. Now finally, I want to talk to you a little bit about our mentors. So once you take a case, the ATAJ program won't continue to be involved. The program doesn't supervise the case. This is going to be your case. Mentors will be available, though, to provide you with advice as you go through your case. The mentors are going to provide information in a Google spreadsheet that you will have access to about the kinds of expertise they have and also the kind of assistance they are willing to give. One important kind of assistance that our mentors have already described a willingness to provide is to help you moot your case before it goes to oral argument. So that's all that I'm going to speak to you about today. Next, David is going to speak to you more about the steps of working with the applicant and establishing the relationship. Thanks.
My name is David Kay, and I would like to thank you for representing a poor litigant in the Court of Appeal. I'm going to give you the first steps that you need to follow when doing a Court of Appeal case. First, you're going to do a conflicts check. You're going to make sure that you have the ability to represent the client. Then you're going to review the notice of appeal, and you're going to review it for two things. Is it timely, and is it an appealable order? Now, it's going to be timely if it's filed within 60 days after the date of the order or the judgment that you're appealing from. If it's not, then you're going to have to look at the date of service of the notice of entry of judgment, and you're also going to have to look at the post-trial motions that are filed. If you're having trouble with that, I suggest you contact a mentor, and they can certainly help you with that. Is it an appealable order? Well, if it decides all of the issues with respect to your client and one other party, it's going to be an appealable order. If it doesn't, it may still be an appealable order, but you're going to have to look for specific code sections that allow for that. The next thing you're going to want to do is have a very realistic discussion with the client. The clients may think that they're going to get a retrial of their case in front of the Court of Appeal and that 3 justices are going to listen to the evidence. That's not going to be the case. They should also understand that legal issues are what are going to be presented. The timeline is also something they need to understand. It's going to take a year to process the appeal, and the results cannot be predicted. You're not going to want to tell the client that they're going to win or that they're going to lose. Look at the bottom line for the client. Do they understand that they may get a retrial of their case after the case is reversed on appeal, or do they think that they're going to win outright at the Court of Appeal? They're probably going to go back to the trial court at some point. Now, there may be issues with possible stays. If there's a money judgment against your client, they're probably not going to be able to post any bonds in order to keep it from being executed. But if there's an exception to that, if it's a cost-only judgment, then there is going to be a stay while the appeal is done. Even though you're not going to be paid for your representation in this case, you are going to want an engagement letter with the client that specifies the scope of the work. You're going to want to sign up to do an appeal, not to represent them in the Superior Court or in the California Supreme Court. If review is granted, you're going to want to limit your representation to the Court of Appeal. Now, you may want to agree to file a petition for review in the California Supreme Court, but not to represent them under this agreement. You want to establish the authority that you have as an attorney, and that includes you are the person to charge of extensions, deciding whether extensions should be given or that you get extensions, and you also want to know if you can negotiate for the client with the other side, and you want that in the retainer agreement. You also want to know what they're going to do with what you can do with the papers after the case. In other words, after the case is over, how long do they have to pick up the papers? What are you going to do with them if they don't pick them up? And you want provisions in your retainer agreement about withdrawing from the case if there is a conflict or they just disappear on you. You want that in the retainer agreement. Your next step is to notify the program that you have accepted, that your client has accepted, and that you are now representing the client. You can do that by email. You'll want to sign up for the True Filing System. We used to have paper briefs that were filed. Those briefs are no longer filed in the Court of Appeal. You're going to be filing electronically, and you do that through the True Filing System at truefiling.com. You're going to want to sign up for that, and you're also going to want to get a credit card ready when you do that, because they're going to be charging you a $10.50 fee approximately to file every paper that you file. You're going to, at that point, you're going to do a substitution of attorney, so that this court will know that you are now on the case, and that substitution and all other papers that they have will be served by electronically on your opposing counsel. You still have to file all your papers in hard copy with the Superior Court. Finally, you're going to be doing a civil case information statement, which is a statement that the court uses to determine if the appeal is timely or if you have an appealable order. You just fill that out. It's on a form which is provided to you by email, and also it's on the court website. You're going to need a couple of things to do that. One is a copy of the order or judgment which you're appealing from. They're going to want to see that. And also some information about your opposing counsel, such as their bar number and information about them, which you can get on the CalBar website. Finally, I think I ought to tell you that you need certain tools in order to file briefs in the Court of Appeal. You're going to need a computer, you're going to need a scanner, and you're going to need Adobe Acrobat Pro or a similar program which allows you to manipulate the documents in Adobe Acrobat so that they can be filed. Thank you for your attention, and now Kevin Green will be telling you about record designation and filing the briefs.
My name is Kevin Green, and I'm a certified appellate specialist. I practiced in San Diego, mainly appellate law, for 20 years, and I'm going to be talking with you today about designating the record on appeal. And this is a really critical area for representing pro se litigants, because you might have a messy record from the trial court. That's one of the first things that you want to look at when you take one of these cases on appeal, to see what sort of record you're dealing with. And in most cases, you'll be representing the appellant, and all burdens, as may be familiar, are on you to provide a complete record to the appellate court. And just keep in mind that the Court of Appeal doesn't know anything about your case beyond what you tell them about it. And that starts with the record that you designate and you assemble. So I'm going to talk about components of that record and issues that are specific to representing self-represented parties in appeals in our program. First, the record designation consists of two components, the written record and the oral record. And I'm going to talk to you first about the written record, or the clerk's transcript. First of all, the record designation needs to be done very quickly. It needs to be done within 10 days under the notice of appeal. And all of the rules of court that govern designating the record are found in Title 8 of the California Rules of Court at courts.ca.gov. So if you go there and you go to rules, you'll find all the rules in Title 8. And the rules governing the record start with 8.120. And there are also judicial council forms, some of which I may also reference during this talk, that are very helpful and speed the process of designating your record on appeal. The 10-day provision has always been one of the few rush things in state appellate practice, but the Court of Appeal is anticipating a 30-day tolling period for the ATAJ program, during which the time to designate is extended by 30 days beyond the 10. So you file the notice of appeal. Let's say you represent the appellant. You file the notice of appeal. Ordinarily, you would have 10 days to designate your record. You would have an additional 30 days if the potential client has applied for the ATAJ program. So we're hoping to build in a little bit more time to do that. Now, the clerk's transcript or the written record, there are a couple forms of the written record, and I'll talk about the others, but the clerk's transcript will be the main one of interest for your types of cases, because a litigant with a fee waiver gets a free copy of it, as opposed to the other forms of that record. And there's a judicial counsel form that is very detailed, but just takes you through step by step of what you want to designate, and that's all the forms are titled APP, and it's App 003. And on that form, you can list the documents that you want included in the clerk's transcript. Now, there are certain mandatory contents, like the notice of appeal and the judgment or order that's on review. But beyond that, the general touchstone, and all of this is in the rules, starting at 8.120, and just going on down from there. But the touchstone is the items that are relevant to the issues that you intend to raise on appeal. And so if there, for example, was a demur and that's not relevant to anything now, there's no reason to designate the demur papers. But you probably would want to designate, for example, the controlling complaint. And let's say it's a summary judgment appeal. It would be all of the papers filed in connection with that, designated for the clerk's transcript. One aspect of any record designation, the written record in particular, is whether you have any sealed documents. And I'm not going to get into any detail of how those are handled. They can be a pain, but it's something to be very aware of because of the confidentiality surrounding those. And the rules governing those start at Rule 8.45. And it's just something to be aware of. Is that something I have in my record that I need to know about? Now, the alternatives to a clerk's transcript for the written record are an appendix, and this is actually preferred by most appellate practitioners. And the main difference is that it's party prepared and not prepared by the clerk. Clerk's transcript is what it sounds like. It's a list. The clerk takes your list of documents and assembles them into volumes, and that becomes the written record for the appeal. An appendix, by contrast, and the clerk's transcript is under Rule 8.122. The appendix is governed by Rule 8.124, and most lawyers prefer it because you can file it with your brief and you assemble it yourself, so you can control the manner of presentation. And if you really want to take a record to the highest level of persuasion, in my view, an appendix allows you to control the presentation much more than a clerk's transcript, so that your record, in a sense, is most user-friendly and is the best presentation that you can make to the appellate court. It has its own persuasive value. And the other benefit of an appendix is when you first get an appeal, it's very common, and it may be with the parties that you represent, that you don't know what the issues are. You don't know exactly. It may not be obvious. And an appendix allows you to designate or select items when you file your brief after you should know all that. And the scope of the record is much clearer. The difference with an appendix compared to a clerk's transcript is that that is not, it's a recoverable cost, but it is not a free item like the clerk's transcript as a written record. And so most cases you'll probably be doing the clerk's transcript, even though that's what most lawyers don't really do these days. In the end, it works just as well, and getting the items that you need to put before the appellate court as context for your issues and for your briefing. The next component of the record on appeal, of the two major components, and this is under Rule 8.120 and 121, is, in addition to the written record, is the oral record of proceedings, and most familiar will be the reporter's transcript of any hearing that is relevant to the appeal. And again, the same touchstone applies, where if there was a status conference hearing, that's probably not relevant to anything. But at the same time, your transcript, if there was a hearing, getting a transcript or some form of what occurred is vital to appellate review. California law has been pretty stringent on this. If there was a hearing on the issues on appeal and there's no transcript part of the appellate record, that can be a major procedural default, dooming your appeal. So that's something that you really need to be aware of, and there are two ways to get that oral record. The main one is the reporter's transcript, and in the fee waiver context, the California Supreme Court issued a landmark decision for access to the courts and access to justice called Jamison versus Desta, and that's at 5 Cal 5th, 594. And there are a number of undecided issues, but the central holding is enormous. And that is that a litigant with a fee waiver in the Superior Court has the right to attendance of a court reporter at a hearing. And that's as far as Jamison went, because that has financial consequences for the Superior Courts, and in fact was in response to the San Diego Superior Court reducing its access to court reporters in civil cases due to severe budget constraints in the last 8 years that may be familiar to you. But this led to really such a denial of access to justice that the California Supreme Court in Jamison said this does not comply with California's law governing informa pauperis, in the Latin terminology, access to the courts and access to justice, and the government code. And so the court held that there is a right to attendance at a hearing that is held. And in fact, there are, at least as of this recording, there are appellate courts reversing under Jamison because no court reporter was provided at a hearing, and in the context, the issue or the argument on appeal cannot be deemed harmless. And so this is a significant development for the record of oral proceedings in the trial court. For California state practice, there are still some open issues, but it's just something to be aware of. So there are cost considerations that govern the reporter's transcript that I need to mention, even though one is a long shot and the other is speculative right now. One is the state transcript reimbursement fund that you can apply for to obtain compensation for a litigant with a fee waiver to obtain a copy of the reporter's transcript. However, that fund is very limited, and I don't know anyone, and I haven't met anyone who has been able to get a transcript paid for by that means. But I do need to make you aware of that. And the other option is a possible grant from the Bar Foundation of the San Diego County Bar. And the foundation may be providing some money in support of this program for reporters' transcripts. The other, in addition to the reporter's transcript, the other form of the oral record on appeal that was not done much 5 or 10 years ago, but because of budget cuts is becoming much more common, is the agreed or settled statement. And this is a statement prepared by the parties, reviewed and often edited by the trial judge, that is a recitation of what occurred at the hearing. And it's the best substitute that anyone has come up with for lack of a reporter at the hearing. And this is an important issue early in the appeal to consider if you're representing a pro se litigant, because it will commonly be the case that one, there were significant hearings, or at least one that's relevant to the appeal, and also that maybe there was no court reporter there. And again, if the Court of Appeal knows there was a hearing, doesn't have some record of what was said at that hearing, has a very hard time reviewing the trial court for abuse of discretion or even on a de novo basis. It needs a copy of whatever was said there. And so the next best substitute is the agreed or settled statement. And these are under Rules 8.134 for the agreed statement, 8.137 for the settled statement. Now, very rarely are you going to have litigants who agree on exactly what was said, or attorneys, if they're in the mix as well. So the more common procedure is the settled statement, where a party applies by motion, and this is in the rules, and it's also in there are judicial council forms you can use for this, the app forms on the California Court's website, where you make a motion within 30 days of the notice of appeal, and you attach a proposed statement, and it's essentially your client's memory of what was said at the hearing. And then the other side gets to attach a proposed statement, and the trial judge has to settle it, which is why it's called a settled statement. And at least, and this may be imperfect, certainly compared to a reporter's transcript, but it is crucial in fulfilling your obligation to present a complete record to the appellate court. At least you've done that much. And the record of oral proceedings won't be a basis for procedurally defaulting the appeal, as often occurs, or did occur before this program.